If you've been following the FAA's war against flight instruction, you probably thought the things couldn't get much worse. I sure didn't. But FAA attorneys seem to have a "you think, hold my Chardonnay and watch this" attitude. The FAA's new stake in the ground is that FAA certified flight instructors can't even provide flight instruction for free in certain aircraft. This is something outrageous enough that it is making the normally soft-spoken large aviation organizations show real anger. We're going to talk about the brand new legal actions that the FAA has taken against flight instructors, and we are going to do that right now. Hi everyone. Several years ago, I talked to someone in the know who said that FAA staff is roughly divided into three kinds of people. There are those who embrace aviation and are personal fans of flying. That's one of the reasons they work there. Then there are those who just look at the FAA as simply another government job. Then there are the dangerous ones, the ones who believe that airspace should only be open to professionals, the people who are military or commercial pilots who make a living flying. That segment of the FAA looks at civilian aviators as a nuisance to be dealt with. As a cynic, I look at the majority of FAA workers as wage slaves. They go in, they do their jobs, they get their checks, and then they go home and watch Netflix. Those people are rather harmless until they are taking orders from someone with less than healthy intentions. Their only professional motivations, if they have any at all, is to get a raise or a better location to work from. Nothing wrong with waiting until Friday so you can go home and have a cookout for the weekend. I like to think that the next largest group of people who work for the FAA do so because they are somehow attracted to aviation. Not enough of them are pilots, but at least they have a positive view of flying. That leaves our third group. I've always thought that the number of FAA staff who are anti-civilian aviation were in the vast minority, but recent events have caused me to reconsider. If it is a small group, they seem to be outspoken in places where it counts. It would appear that the people who drafted Advisory Circular number 61-142, sharing aircraft operating expenses in accordance with section 61.113C, aren't pilots themselves. And it certainly appears the FAA attorneys who are enforcing this document don't seem to be very familiar with general aviation or pilots who participate in flying. Of course, I could be wrong since I don't know any of these people personally, as far as I know, but I am open to wagers. Let's get to the evidence that the FAA is off the rails. AOPA reported last week that flight instructors who were quite literally volunteering are being told by the FAA that they are receiving compensation as defined by that unfortunate Advisory Circular 61-142. A story published on July 14th by AOPA's Justine Harrison is titled, "Anyone Giving or Receiving Instruction in a Limited Primary or Experimental Category Aircraft is at Risk," with the subtitle, "FAA Prosecutors Pursuing CFIs Providing Training for Free." I'm going to read this straight from the story. The FAA issued a new directive effective July 12 that provides notification on flight training for compensation in certain aircraft, specifying it applies to receiving and providing instruction in limited primary and experimental category aircraft. Meanwhile, in court proceedings, the FAA is prosecuting flight instructors who volunteered their time instructing in limited category aircraft and didn't receive a penny for doing so, arguing the volunteers had received compensation. The FAA argued in court that flight instructors who volunteered their time training pilots in limited category aircraft were given compensation whether money changed hands or not. The recent FAA directive requiring approval to provide compensated instruction also applies to experimental and primary category aircraft. The story quotes AOPA President Mark Baker as saying, "The FAA can't have it both ways," while claiming it is clarifying the situation. This is contrary to the FAA's mission and obligation to promote safe flight. And Mr. Baker has it right. It is completely outrageous for the FAA to say that someone volunteering to do something is in fact being compensated. This is actually worse than even the IRS. Imagine if the IRS looked at volunteer work that way. Volunteers would probably be taxed for working in soup kitchens since the people eating the soup said thank you. Back to AOP's story. Last week, FAA prosecutors quoted FAA Advisory 61.142, defining compensation as a receipt of anything that is contingent on the pilot operating the aircraft. It does not require profit motive, or actual payment of funds. Accumulation of flight time and goodwill in the form of expected future economic benefits can be considered compensation. Furthermore, the pilot does not have to be the party receiving compensation. Compensation occurs even if a third party receives a benefit as a result of the flight. It is important to point out here that the Advisory Circular 61-142 isn't a law or regulation. It's barely a policy. In fact, the document itself includes this language in the second and third paragraphs. The material in this AC is advisory in nature and does not constitute a regulation. This guidance is not legally binding in its own right and will not be relied upon by the Department of Transportation as a separate basis for affirmative enforcement action or other administrative penalty. Conformity with this guidance document, as distinct from existing statutes and regulations, is voluntary only, and nonconformity will not affect rights and obligations under existing statutes and regulations. The contents of this document do not have the force and effect of law and are not meant to bind the public in any way. The document is intended only to provide clarity to the public regarding existing requirements under the law and agency policies. This document describes acceptable means, but not the only means, for demonstrating compliance with the applicable regulations. The FAA will consider other means of compliance that an applicant may elect to present. While these guidelines are not mandatory, they are derived from extensive FAA and industry experience in determining compliance with Part 61. The content of this AC does not change or create any additional regulatory requirements, nor does it authorize changes in or permit deviations from existing regulatory requirements. Can it be any more clear that AC 61-142 is advisory with a small a? Back to AOPA story. The FAA alleged volunteer instructors receive compensation by accumulating flight time and generating goodwill. In other words, the FAA believes giving away your time and talent equates to compensation. While pilots and flight instructors receiving and giving flight instruction in standard category aircraft are not affected by this recent move, it is a roadblock for those seeking instruction in these three specific categories of aircraft, potentially causing some to forego proper training and therefore impacting safety. Until July 12, the FAA never required students who provided experimental aircraft to have a LOTA to receive flight training and flight reviews. Now the FAA clarified that owners and operators of more than 39,000 experimental aircraft, as well as the CFIs who provide instruction in them, need LOTAs in place to receive or give compensated instruction in those aircraft. But in reality, it doesn't appear to matter if no money is exchanged in instruction in limited experimental or primary aircraft. The FAA is arguing that anything is compensation solely because the FAA labels it so, and that it can prosecute a flight instructor for someone else receiving compensation, even if the instructor receives none. The overreach and refusal to draw limits is breathtaking. And that is exactly true. In fact, the more difficult and outrageous the rules, the more the FAA risks people ignoring them entirely. We are already seeing that on a regular basis. AOPA goes on. So what does this mean for pilots who want to receive a flight review or transition training or just brush up on techniques with an instructor in their limited primary or experimental category aircraft? And what does this mean to the instructors who want to teach them? To stay out of the FAA's legal crosshairs until the courts decide whether the FAA's legal arguments are winning ones, you'll need to get the FAA's permission first. For training in experimental aircraft, that means obtaining a letter of deviation authority as outlined in the July 12 directive. For limited and primary category aircraft, that means obtaining an exemption. Flight instruction is a noble profession, one that takes a significant investment in terms of time, money, and effort. Flight instructors deserve to earn a living without needless bureaucracy. Pilots, particularly those who fly unusual aircraft with unique flight characteristics, need access to training without meaningless approval processes that have no impact on safety, beyond degrading it by delaying training and adding barriers to access. Can there be flight training that doesn't result in hours of experience for the instructor or student? Why did the FAA issue a policy that targets flight training for compensation if it also argues that there is no situation that doesn't fit the kitchen sink definition of compensation? It sure would be nice if it could clarify that. Of course the AOPA is correct here. This is the place where I normally ask for an upvote from you. But honestly, I'm not asking for one here. What I would prefer is for you to share this story with your pilot friends. You can share this video, or you can go down to the description where I have the link to the original AOPA story and just share that. It doesn't matter how the story gets out, it just matters that it does. Something else is wrong too. FAA's selective enforcement seems a little suspect. It seems that they are targeting one specific segment of aviation right now. It's primarily warbirds, and they don't care who else they hurt while trying to clamp down on those guys. Just like a couple of years ago when they targeted a couple of companies that offered ride-sharing apps. Those companies were offering new technology that would have helped general aviation pilots share costs with people wanting to go where pilots were already flying. In fact, that seems to be the reason for creating the horrible AC 61-142 in the first place. That clampdown didn't just target the companies offering the apps. It targeted all sport and private pilots who were looking to make flying just a little more affordable by sharing expenses with others. Who is next? Maybe it's someone on the list of people affected by the FAA's own poorly created regulations. I'll put a card up here in case you want to see the 7 large groups of student pilots and flight instructors at risk by the FAA's definition of flight training as operating an aircraft for higher compensation. In any case, my big hope is to return to flying topics for my next video. Because A, I don't like doing these kinds of videos no matter how important they are, and more importantly, B, I hope that FAA doesn't figure out something new and dumb to do for at least a week. Let's all cross our fingers. Finally, if you are interested in powered parachute flight instruction in either the Midwest or in Florida, please visit the link to easyflight.com in the description. Flight instruction is the best way to get introduced to piloting, even if the FAA makes it more difficult. And please remember to share this story with your pilot friends. Thanks so much for watching, and blue skies.